Well, good morning and welcome to the May 2019 meeting of the New York City Campaign Finance Board. The first item of business is the approval of the minutes from the April 18, 2019 meeting. I move their approval. Is there a second?
Second.
All those in favor? Aye. Opposed? Abstentions? The motion carries. Next item of business is the report of the chair. So the special election in City Council District 45 was held earlier this week. The board paid $752,360 in public matching funds to 6 candidates in this race. Thanks to all the candidates who ran for their commitment to making New York City a better place to live. Now the CFB staff will begin the post-election auditing process for all 8 campaigns on the ballot. The CFB offers a seminar to help campaigns understand the post-election audit process. CFB staff will walk attendees through all steps in the audit process, offer tips on how to organize the campaign's response during each step, and provide guidance on common audit findings and how to avoid them. Attending a post-election training can help expedite the issuance of a campaign's final audit report. Special election candidates should contact their candidate services liaison for more information. Now I'll turn to our Voter Assistance Advisory Committee Chair, Naomi Zouderer, for her report.
Thank you, Chair Schaefer. As you've mentioned, the special election to fill Jumaane Williams' vacated city council seat in South Brooklyn was held earlier this week. Farrah Lewis was declared the winner, according to unofficial results. They will serve out the remainder of the calendar year as a member of the city council. The Voter Assistance Advisory Committee and NYC Votes took a number of steps to inform voters in the district about this election and provide resources to help them make an educated decision at the ballot box. We advertised on social media and in local papers, urging voters to visit voting.nyc and read the voter guide. Volunteers helped us call hundreds of voters on the weekend before the election, and our email and text campaigns helped to get the word out to even more people. Our voter guide included video statements and profiles for each of the 8 candidates on the ballot. The profiles outline each candidate's top issues and their professional and civic experience. While Farrah Lewis was declared the winner of the special election, all 8 of these candidates will be back on the ballot in the June primary. This upcoming election will feature a very competitive Democratic primary for Queens District Attorney. Our voter guide and Get Out the Vote promotions for the primary election begin in mid-June, so stay tuned. Earlier this month, NYC Votes released its voter analysis report on the 2018 midterm elections. This was a landmark election cycle for New York City, which saw voter turnout rates in the general election nearly double from the previous midterm election in 2014. The report provides in-depth analysis of voter participation, including maps and charts displaying turnout by neighborhoods and by demographic factors like age, race, citizenship, and daily commute times. You may have heard that early voting is coming to New York later this year, something that voting rights advocates like all of us here are very excited about. In order to make sure that this reform is implemented in a way that makes sense for the millions of busy voters across New York City, we sent a letter outlining our recommendations to the New York City Board of Elections last month. And with that, I will turn to Executive Director Amy Loprest for her report.
I just have one thing. I just want to announce to the board that Sabrina Castillo, who has been a member of the staff for a long time, has been promoted to the Director of Partnerships and Outreach and will be coordinating our work on voter engagement and outreach throughout the city.
Thank you. The next item on the agenda is our new tradition of announcing campaigns in compliance. So the following candidates from the 2017 elections have completed the post-election audit process without any violations or penalties assessed by the Campaign Finance Board. The board recognizes the diligence of the candidates and their campaign staff in running campaigns that maintained compliance with New York City's campaign finance law. There were 2 such candidates. Michael Scala, a candidate for City Council in District number 32, and Thomas Sherbenko, a candidate for borough president. Next item on the agenda are candidate appearances. We have 5 matters to take up with respect to penalties, but of those 5, only 2 appearances by candidates. The first is that of, forgive me if I'm pronouncing this wrong, is it Zayad Ramadan? Mr. Ramadan, why don't you and your representative take a seat at the table here? CFB staff will get seated at the other table. So the way we proceed, probably not surprisingly, they will go first and really very briefly just tee up what the issues are. Not really an argument, but just sort of make sure we're all on the same page as to what the issues are. I'll then turn to you for your presentation. Inevitably or frequently there are questions from the board. Occasionally we'll go back to the CFB to answer some of our questions or to respond to any points that you've made. And in due course, we hope this back and forth peters out and we can end, at which point we're going to do one more candidate appearance. Then we go into deliberations, and then when we come back, we'll announce our decision. So why don't you guys start first?
Thank you. Good morning, Chair Schaefer, Executive Director Loprest, members of the board, Mr. Roche, Mr. Ramadan. Before the board is the matter of the Ziyad Ramadan campaign in the 2013 primary election for City Council District 7. Mr. Ramadan was a participant in the program and received $50,731 in public funds. CFB staff is recommending that the board assess penalties for the following violations: failing to report transactions, failing to demonstrate compliance with reporting requirements for receipts and disbursements, filing late disclosure statements, failing to demonstrate compliance with subcontractor reporting and documentation requirements, accepting contributions from corporations, limited liability companies, or partnerships, accepting a contribution from an unregistered political committee, failing to document transactions, making cash expenditures greater than $100, failing to demonstrate that spending was in furtherance of the campaign, and exceeding the expenditure limit. The campaign contests 8 of these alleged violations.
Thank you. Gentlemen, the floor is yours.
Good morning, Board Chair, Executive Director, and Board members. Sorry, I didn't turn on my mic.
Could you enter your appearance?
Pardon?
Could you enter your appearance?
Sorry. David Roche, that's R-O-C-H-E, of the law firm of Ahmed and Roche, LLP, for Ziyad Ramadan. Good morning. There's a unique, the campaign of Ziyad Ramadan 2013 presented a unique set of circumstances that has resulted in it getting this far and bringing us here today. Just the unique circumstances were that towards the end of the campaign, or right in the middle of the campaign, the campaign manager, who was Bill Lynch, who's like a very well-known person in New York political campaigns, died in the middle of the campaign, which created some disarray in the campaign. The duties of completing the paperwork for the campaign and providing information to the campaign finance board fell to the designated campaign manager who had been hired by Bill Lynch Associates. That person's name was Jason Eligio. Mr. Eligio failed to respond to the draft audit report. The draft audit report listed a number of violations and suggested information that could be provided for each one of the alleged violations. Many of those violations could have been resolved because the campaign had kept detailed records, and it would have been just a matter of going through the records and answering the questions that were presented by the campaign finance board. Mr. Eligio, for whatever reason, failed to do that, and he didn't respond to the draft. And then sometime later, the penalty notice was sent back to the Campaign Finance Board, purportedly signed by Mr. Ramadan and by his treasurer, Razul Miller. Mr. Ramadan did not sign it himself. Somebody forged his signature on this document. We could speculate as to who that was, but bottom line is his signature appeared on it that did not belong to him. Mr. Miller also contests that he did not sign it either. And it makes total sense because neither of them would have had any incentive to accept penalties amounting to over, like it was, I think it was $113,000, when it was very clear that most of these penalties could have been eliminated or drastically reduced just by answering the questions posed by the Campaign Finance Board. So that's, it's a kind of a unique circumstance that happened. And then it placed the campaign and Mr. Ramadan and Mr. Miller in a very difficult position because the penalties had been accepted. So as far as the Campaign Finance Board was concerned, the process was over. The campaign hadn't contested the penalties, so there was no real process after that for it to be reviewed or reopened. And there's been quite a lot of procedures since then, but we've been unable to resolve this matter. The campaign, Mr. Ramadan's campaign in 2013, it was his first time ever running for political office. Before that, he had a long history in community associations, charity work. He'd volunteered for a number of organizations. He'd served on his community board for 15 years, chaired the board for 2 years. He's the founding chair of a civil rights educational center, the Malcolm X and Betty Shabazz Memorial Center, and he was the founding chair of the Northern Manhattan Arts Alliance, and also was a volunteer with very many other community organizations. So he really was committed to community service, so it was kind of a natural step for him to run for office. Because he hadn't run before, he hired someone who he felt was the most experienced person that was available in New York politics, and that was Bill Lynch. And he was relying on Mr. Lynch to help him understand the campaign finance regulations and to run a well-organized and ethical campaign. And that was the intention from the very beginning, and that was what kind of a campaign they ran. It was a well-organized campaign throughout the whole throughout the campaign, and the detailed records were kept. Every transaction, receipts were kept, no matter how small the transaction. Bill Lynch Associates did most of the hiring for the campaign. Mr. Ramadan hired Mr. Miller to be his treasurer, but other than that, the rest of the campaign staff was pretty much hired by Bill Lynch, and they handled the day-to-day running of the campaign. There was a campaign manager, Ms. Morazan, who only lasted for a short time, and then Jason Aligio took over and basically was the campaign manager for the campaign. So throughout one aspect of the campaign that I think is very relevant for the violations that have been imposed is that there was a litigation. There was a petitions challenge brought by Mr. Ramadan, and he hired a lawyer, Mr. Ali Najmi, who was paid, I believe, like $10,000 in fees. I have provided a letter from Mr. Najmi previously, and Mr. Najmi has provided another letter today, which I would like to provide to the board, which breaks down the work that he did on for the petition challenge litigation. So he In the letter, he details that he worked approximately 25 billable hours at $300 an hour, which comes to like $7,500. And there was $1,000 in costs for that as well. And that doesn't include the work by the campaign staff in examining petitions, serving subpoenas, and basically providing support for Mr. Najmi in this litigation. And I will talk about that a little bit later, but I have copies of Mr. Najmi's letter that I can provide.
To what issue does this letter relate?
Okay, so that goes to the exceeding the expenditure limits, because we will argue that this is exempt. Okay. So another thing that happened that's unusual in this campaign is that after the election, Mr. Ramadan lost the election. After the election, they packed up their campaign office, and the records were retained by Bill Lynch Associates. When it became later on, when there became an issue when they realized that there was an issue with the Campaign Finance Board and that they needed to obtain the records, the records have somehow not been. Bill Lynch Associates have been unable to find the records. I personally have made several efforts to try and get records from Bill Lynch. I've sent letters. I've asked to be able to go to their storage space to look for it ourselves. That opportunity has not been provided to us. And bottom line is, Bill Lynch Associates seems to have lost the records, and we have.
George, I'm sorry, but because this relates to some of the points you've been making, so I'd like you to address it now. Is you've articulated that Bill Lynch, sorry, that Bill Lynch Associates had responsibilities for dealing with the Campaign Finance Board, with compliance. $15,000 was paid to the treasurer. That's normally the treasurer's responsibility? What was the treasurer doing for the $15,000 that the treasurer got?
Well, the treasurer was working on the finances like throughout the campaign. Like at the end of the campaign, it was the responsibility for dealing with the audit was on Mr. Eligio. Okay. So Mr. Miller had various different functions in the campaign, but he was primarily responsible for the finances of the campaign. He expected to work with Mr. Eligio in responding to the Campaign Finance Board, but Mr. Eligio was the point person, and Mr. Ramadan expected to work with him too in answering whatever questions that the Campaign Finance Board would have had. The problem is that they really didn't get an opportunity to do that because the notice was signed off. The notice of penalties was signed off on without them being consulted and given an opportunity.
Well, the earlier communications went to home addresses before people moved. So, I'm not sure. Yes, the penalty notice, but I'm not sure that washes for some of the early audit issues. Communications.
I believe that the notice was sent to my client's old address. I don't believe that he received it.
I think the record shows that the first notice was sent to the old address at a time before there had been a move.
I don't believe that that's accurate.
No, well, we'll double check that. But as you gather from Mr. Davis's question, you're going to have a hard row to hoe. Because the law is pretty clear that the candidate and his treasurer are ultimately responsible and liable. And therefore, I think it behooves you, although you can organize your presentation as you choose, to address various factual gaps and questions directly. It is possible that your introduction on the equities might have some influence on some of those specific things, but I think it's best for you to turn as quickly as you can to specific factual, what you consider to be errors or misunderstandings that underlie each of the penalties because I think to the extent that you're going to be successful here today, it's going to depend on addressing those specific facts.
Okay, and I'm prepared to do that. If I may, like I could start with the largest penalty, which is
Always a good place to start.
which is number 10, which is exceeding the spending limit. I believe that there are not necessarily errors, but there's inaccuracies in the calculations. Are not exempted from the calculations, and I would submit that they should be. Mr. Najmi's letter makes clear that $7,500 is directly attributable to the litigation, which should be exempt. I would argue that some of the other $2,500 that was paid to him could also be argued to be related enough to the litigation that some of that should be included too. He documented $1,000 in costs that was directly related to the litigation also, and he explains how this campaign staff also assisted. And there was significant assistance by the campaign staff. There was a lot of work that had to be done in challenging these signatures. They reached out to thousands of people who had signed, and to question the validity of their signatures and who obtained the signatures. And then subpoenas had to be served on a number of these people. I believe 41 subpoenas were served by the campaign staff to bring signers in for a hearing. So we've.
Does his letter calculate the amount of campaign staff time that was spent? And if not, are you prepared to give us an estimate as to what you believe and can document
Right.
was the amount of their time?
So we have estimated it as at $7,500, and I believe that's a very, very conservative estimate
For the campaign staff?
for the campaign staff.
That's just a coincidence that it's the same number as his fee.
It was that number was actually given before Mr. Najmi gave his number.
Okay,
So-
thank you. Okay.
Can I ask you a question? Did you claim any of that as exempt? Because one of the requirements, also as part of when we ask for documentation is when you indicate that you want to claim things as exempt, the staff asks for additional documentation to demonstrate it, and that if you did not claim it as exempt, the staff would have no reason to ever ask for that documentation, which would leave us to the conclusion that today, 5 years after the election or 6 years after the election, you're bringing documentation of what is exempt and what isn't exempt.
Well, the very unusual circumstance is that the penalties were accepted by.
I understand that, but even in the draft audit, we would never, or in our initial document request, we never would have asked for that documentation because they were not claimed as exempt. It's clear in the Canada Handbook and in the guidance that's given by our staff that when you want to claim things as exempt, even though there are only a very narrow number of things, petition litigation, as you've indicated, are considered exempt from the spending limit, you actually have to tell us that you want them to be claimed for as exempt from the spending limit, so the staff can ask for the documentation contemporaneously. And I understand all the procedural things that happened here, but the staff never asked for that exempt documentation because you never claimed them as exempt.
Well, I did. Because in April of last year, I was given an opportunity to present a response to the draft audit report, and in that response, I did claim. I believe I claimed $10,000. I believe I claimed Mr. Najmi's entire fee, and he provided a letter explaining that that's how much that he had. That's how much he had been paid for his work on the campaign. Since then, the board or the campaign finance staff had asked for further clarification, or they had explained in the most recent report that what we had provided was not sufficient to document how much work was actually attributable to the litigation. So that's why we obtained the most recent letter from Mr. Najmi. And the last report that I got from the campaign finance staff was dated May 8, 2019. So
Yeah, that's the staff's recommendation to the board, not an invitation for more documentation. I mean, that is the staff's conclusion of the documentation that's been submitted to date.
I believe this was addressed in the oath petition as well, because that was in response to the first time that we had gotten any indication that the campaign was claiming these expenditures as exempt. Was we indicated in the oath petition that the documentation submitted was not sufficient, because the rules regarding exempt expenditure documentation are very rigorous and the provision in the act is extremely narrow. It applies only to petition litigation specifically, which the letter that we had from Mr. Najmi listed a number of different tasks, only one of which was specifically subject to the exempt provision, and did not contain any detail in terms of the hours spent, the rate, the specific tasks performed. The documentation as provided in the rules has to be contemporaneous and detailed in order to be exempt. And so, I haven't seen what this letter is today. I would remind the board that under Rule 702C2, you do have the discretion to disregard documentation not submitted timely. However, we would need an opportunity to review this to know whether it even would satisfy the standard for exempt expenditures.
Why don't we just pause for a second for you to give a copy to Ms. Persky, and if you have an extra copy, one for us, and we'll get copies made, further copies made if that's all you have. Yeah, okay. Okay, well, we'll share.
So this appears to be essentially a restatement of the first letter. What we really need is an invoice, what you would see traditionally from an attorney, billable hours broken down, much more specific than this and much more detailed and exacting than to say, I estimate that my full billable time was about 25 billable hours.
Okay. Why don't you continue?
So, I can, whatever the board needs, I can ask Mr. Najmi to provide it. I think he's making an effort to provide information that has been requested. I think his letter is pretty clear, but if additional documentation is needed from him, I would ask for an opportunity to ask him.
I'm not sure at this late stage. We'll have to discuss it in deliberations whether we're prepared to accept any further documentation. I think what Ms. Persky is saying is ordinarily what we would expect would be contemporaneous timesheets of the type that lawyers normally keep, showing what their time exactly amount of time spent on each specific task. And this letter is of a more general nature, but let's keep going.
Okay. So also included in the exceeding the spending limit calculation is a calculation of in-kind contributions by a number of contractors or staff on the that worked on the campaign. One of them was for Sykes Global, and I believe that the amount was attributed to Sykes was like 5,500, I believe. What happened with Sykes, I believe Rhonda Sykes is the name of Ronnie Sykes is the name of the person, is that she provided consultation on the campaign for the first half of the campaign, and her services were terminated at a point in the about midway through the campaign, because she really just wasn't producing any worthwhile contacts, or it was determined that she really wasn't providing sufficient assistance to the campaign, so her services were no longer required. So she had been paid up to that point, and she was paid no further payments after her services were terminated.
And what is the evidence that her services were terminated, and what evidence exists, if any, that she does not still have a claim against you?
So we have asked Ms. Sykes to provide us a letter, and while she has acknowledged in person to Mr. Ramadan that she is not owed any money, she was unwilling to provide a letter. The
I asked her yesterday.
okay, please stop. So look, we don't have documentation. Obviously, there may have been communications that would have been in the campaign file that we don't have access to. But we don't have, like, we have asked her for a letter. I can't think of anything else that I could do at this point to provide that. But the documentation that the Campaign Finance Board is in possession of shows the payments to Ms. Sykes that stopped halfway through the campaign. So that's that's consistent with our contention that it was just simply, she worked for half the campaign, she stopped working, she was paid for everything she did, she didn't get paid for the things that the months that she didn't work.
If you don't mind, I'd like to ask Mr. Ramadan directly whether it's your testimony that she did not provide services beyond the roughly midway point of the campaign.
Yeah, absolutely not.
Okay, thank you. With regard to the claimed in-kind contribution from Bill Lynch Associates, I believe there was Bill Lynch Associates was paid that was largely due to the fact that Bill Lynch himself died and was not providing any. He wasn't working for the last couple of months of the campaign, so Bill Lynch Associates didn't expect to be paid for the work that obviously he wasn't able to do. There's no. We've also spoken to Bill Lynch Associates and asked them for a letter. I think the last response we got from them was that they were checking with their compliance people and they'd get back to us, and we haven't gotten any.
So this one is a little bit different from Sykes in that although Bill Lynch tragically died and you did not get the benefit of his services at the last part of the campaign, you continued to use this firm as your consultant into the post-election and audit process, which does not seem consistent with the idea that you had fired them and that they had ceased to perform and that therefore you didn't owe them any more money. Would you please address that?
Sure. Absolutely, they were not fired. The Bill Lynch Associates continued to work. They're the employees that they had hired but that were paid directly by the campaign separately continued to work on the campaign. But it's just Bill Lynch himself, who was the main person, conducting the campaign, was no longer.
Was the contract just for campaign services, or was the contract also for post-election services?
I would need to check that, but I believe it was for. I would need to check that the actual contract on that. But Bill Lynch Associates are not claiming that they're owed money from the campaign. Their position is that they've been paid in full, and they have confirmed that verbally, but they just have not provided a letter. So we don't have documentation, in that regard. But I think it's pretty clear that. The contract at the beginning that was entered into at the beginning of the campaign is to some extent it's like a projection because it can be modified depending on how the campaign goes. And in my understanding, the firm understanding is that Bill Lynch Associates their position is they've been fully paid.
I'm sorry, I don't want to interrupt. I just have it in front of me. The original contract goes from February 1st, 2013 until the end of the primary race as determined by the Board of Elections. So that would not cover the post-election period.
Okay. There's also an in-kind contribution that's calculated as to April Tyler. April Tyler was her services were terminated pretty early on in the campaign. It was just found that she really wasn't being effective. She wasn't making the contacts in the community that were expected of her. So her services were terminated, and I believe the documentation and the checks paid to her show that they stopped at a particular time, and she has been paid in full too.
Any oral or written acknowledgement by her of that?
One second, did you speak to Tom?
There was no sort of
Right.
paperwork followed.
Okay, and I believe there has not been confirmation with Ms. Tyler, but I don't think there's any dispute as to it. It was pretty clear that her services were terminated, and okay, Mr. Ramadan just has informed me that it was actually Mr. Lynch himself who terminated Ms. Tyler's services. And the payments to her, which had been, regular payments, stopped at that point, and the bank records show that.
I have a question on this one because the documents, your documents show that she was terminated after about a couple of months, and her contract was for $1,000 per month, but she was actually paid $5,500 out of the $7,500. So I don't understand. It looks to me like she was overpaid. Why would she? I mean,
I think the campaign's position would be that she was overpaid. I'm not sure that we have the exact date that her services were terminated. I think we estimated it in our response, but she was terminated, pretty early in the campaign. But she may have been paid for a little bit, maybe she was paid for 30 days after she was terminated. I'm not exactly sure, but she was terminated, and she was not paid the full amount that she would have been paid under the contract if she'd worked the entire campaign. The exceeding the spending limit calculation, I believe, comes to over $10,000. The in-kind contributions component of exceeding the spending limit comes to over $10,000. I believe that that amount should not be included in that calculation, and the payments to Ali Najmi and to the campaign staff for the litigation should be exempt. And that would eliminate the exceeding the spending limit component entirely, and it would show it. I believe it's clear that the campaign did not exceed the spending limit and actually came in under the spending limit. So we would ask that be eliminated.
One interconnected point is you're also contesting failing to demonstrate that spending was in furtherance of the campaign. These additional payments to Mr. Miller, Mr. Fitzroy Searles, and to Aisha Ahmad, and maybe there's one more. Yes. And now, do you understand that if we agree with you on that, and say there's no penalty because they were in furtherance to the campaign, those then get added back into the expenditures. Mm-hmm. So that would increase the amount of the expenditures. So I just want to make sure that you understand that.
Okay.
And those total about $7,450.
No, I think that's too.
No, I think it's
No, it's
that's right.
$39,50, $500, $1,000, and $2,000.
That argument's a two-edged sword.
But I think that the amount that's listed for that alleged violation for the spending in furtherance of the campaign is calculated at $1,912.
That's the penalty.
That's the
Penalty.
That's the penalty. But the amounts that yield that penalty add up to $7,450. Now, you could decide not to contest that if you want, but if we and I haven't made a judgment as to our reactions. I just want to be clear that if we agree with you, that amount gets added back into how much the campaign spent.
Right. Well, for those payments, it was the contracts with Mr. Miller and Fitzroy Searles, they were more like a projection too, of kind of what the expected work that they did on the campaign would be. But obviously, like as the campaign comes towards the final month or whatever, they're working more time than.
Is your position that all these amounts were amounts that were working actively on the campaign and justified by the campaign? So we should count then these as campaign expenditures.
I mean, we would still argue that there's no documentation to substantiate those statements, but if you do decide that they are campaign related, then you're correct that they should be added to the spending limit. But we would our position is that when work is performed outside of a contract, there needs to be an amended contract or some other type of documentation to substantiate that.
Right. And
I just wanted to clarify what the position was today, given all the interconnections between the various penalties. Sorry.
yeah, so we would I just need to consult with my client a little bit on this particular component, but it is our position that that any payments that were made to Mr. Miller and Mr. Searles were for their work on the campaign. So let's see. So I believe the next number that I would like to look at is number 5, which was accepting contributions from corporations and limited liability companies or partnerships. So this deals with the Sykes Global, Ronnie Sykes situation again. Our position is that she was terminated early and paid in full for the work that she did. Same thing with Bill Lynch Associates. So this is kind of a rehash of the point that I made. Yeah. There was an additional corporation here, Nassif Hassan Physician PC. That was an oversight by the campaign, that they just didn't realize that a PC was a professional corporation. And as soon as they realized that that was something that had to be refunded, they refunded it. We don't contest that was a mistake, but the payments from or the payments to Sykes Global and BLA, Bill Lynch Associates, it's our position that they were paid in full and that there was no in-kind contribution from them. So we would ask that be eliminated, that component be eliminated, also except perhaps for whatever penalty would be imposed for the mistake with regard to Dr. Hassan. So I believe number 8 is one that I would like to address. That's the making cash expenditures greater than $100. For this calculation, every ATM withdrawal, every cash withdrawal that's for over $100 is considered an expenditure greater than $100, and that absolutely was not the case on the campaign. The campaign staff members would go to the ATM to get cash that would be put in the petty cash, and then various minor expenditures would be paid for using that cash, like paying for pizza, paying for food that gets delivered for campaign volunteers, getting car service, various different like small expenditures. Receipts were kept for every single transaction. Obviously, we don't have them because the records have been lost, misplaced, can't be found. But I think it's unfair. And it's kind of arbitrary. There's no real reason to assume that every cash withdrawal corresponds with a payment. Obviously, people take out cash and then use it to make a variety of small purchases. So I would ask that be eliminated too. I think the amount is $1,644, and I think that the basis of that calculation is arbitrary, and it shouldn't be upheld. I believe most of the others are kind of smaller, but I can respond to them. Number one is failing to report transactions. So the campaign kept a record of every single transaction. Receipts were kept for every cash purchases. But for the fact that the records can't be found, we would be able to provide an explanation for every transaction. Now, at the kind of unique circumstance here is that the notice of penalties was accepted without any opportunity to go over provide the information that the Campaign Finance Board was requesting. If my client had an opportunity back then before the penalty was accepted, he obviously would have tried to get the records at that point, and they may not have been lost at that point, and would have been able to provide records of all the transactions, because he's very clear that they had a rigid system that every single transaction, no matter how small, receipts were kept, so they would have had records of those transactions. So while it's not a very large amount, that the penalty for this, I believe, is $600 or something. It is something that if the penalties had not been accepted in the forged manner that they were, this is something that could have been resolved by providing records of the transactions earlier. So as to number two, failing to demonstrate compliance with the reporting requirements for receipts and disbursements, similar kind of response. If the signatures had not been forged, the bank statements could have been provided. At that point, the bank statements are accurate as to the money that was used on the campaign, and documentation could have been provided that would have eliminated this violation earlier and this penalty earlier. As to number three, filing the late disclosure statements, we're not contesting that. There were two disclosure statements that were filed a day late, so we don't contest that. As to number four, it's the campaign's position that subcontractors were not used, but we don't have documentation to prove that. But it is our belief that subcontractors were not used. Number five, I referred to. Number six, accepting a contribution from an unregistered political committee.
Honest error.
So that was a campaign error. It was a contribution from a PAC that was accepted in error and was refunded as soon as it was brought to the campaign's attention. Number 7, failing to document transactions, is a $200 penalty for that we have not contested, just because we don't have the documentation to be able to contest it. And cash expenditures, number 8, I've referred to, and number 9 we've discussed also. So I believe that's
Thank
all
you.
of the numbers.
That's
Didn't discuss, that was the contract dates.
anything further?
No, thank you.
So just,
Percy?
just a few things. First, I want to address the cash expenditures greater than $100. The reason that there are very rigorous cash reporting and documentation requirements is that cash is extremely high risk. It is untraceable. If a campaign withdraws cash, we need to know where that ends up. There are petty cash journal requirements. There's an option in CSmart to create the petty cash journal and report as you go. We don't have any of that documentation. And so in the absence of that, we have to assume that the withdrawals constitute cash expenditures over $100. I also just want to clear up, there was a question earlier. Mr. Ramadan had stated to me that he moved in July of 2015 when we spoke on the phone, and the first penalty notice was sent in August of 2015. So that was shortly after the move, and it would have been sent to the address we had on file at the time. Board rule,
But the memo said something different.
I believe that's about the draft audit, which was sent prior to the move. Well before. Well, the draft audit was sent well in advance of the move.
Right.
Also, both documents are uploaded to C-Access, which sends a notification to all of the email addresses on file, indicating that you can go on and access that online. And also, Rule 111B requires that candidates notify the board in a timely manner of change of any material information, which would include mailing address.
Okay. Well, thank you. If there's nothing further, we will, after hearing the next candidate, go into deliberations. Did you want to wind up with a peroration?
If I may, I would just like to say that the campaign, there's no evidence of any malfeasance in this campaign, that there's anything done with any kind of dishonest intent. The circumstances are very unique and unusual, and it's put Mr. Ramadan in a very difficult position. His contention is that everything was documented, that they really did run a very well-ordered campaign, and that the records were there. It's just they hadn't been misplaced. We would be able to provide documentation to support our contentions much more than we've been able to do so. The recommended penalties would be an extreme hardship for him. Right now, he's going through a period of pretty extreme financial stress. He was a small business owner for several years. He ran a number of cafes, which all of them have gone bankrupt, and he does not have any cafes anymore. So he's currently not employed, and he's trying. He runs with his wife a small catering business, but it's not really making any money. So for the kind of penalties that are recommended would be really, extremely detrimental to Mr. Ramadan and his family, his finances. I just want to make the board aware of that. And I just, for all the reasons that I've explained, I don't believe that penalties, except for maybe some very minor penalties for the mistakes, some pretty minor mistakes that were made. I think the larger penalties are not really appropriate in considering the circumstances of this case, and I would just ask that.
I just had one quick question. Is there a reason that the campaign treasurer is not here?
If I might, Ms. Brackett, attorney law board today, we met with the rest of the board, and this time we have University of Pennsylvania, they approved that to finish up the CHP work. I've had extensive conversations
can I just ask two quick questions just for clarification? So who in the campaign was responsible for preparing the disclosure statements? Did the people from Bill Lynch Associates do that, Mr. Eligio, or someone else? Or did the treasurer prepare the disclosure statements during the campaign?
The disclosure statements.
The ones that you file with,
Disclosures
yeah.
on a periodic basis during
I
the
mean, if you don't
campaign.
know, you don't know. That's fine. I
Yeah,
just
it
was wondering.
It was Jason Eligio and Rasul Miller were the
Okay.
ones who were.
They did it, okay.
So yeah, we filed our disclosure statements on time except for those 2 days.
No, I understand. And then did you have any conversations with Mr. Eligio? I'm sorry, mispronouncing his name, after the campaign, since he was responsible for preparing your response to your audit, that I assume that you knew was going to happen? Did you have conversations with him? Because he did ask for a number of extensions and was in contact with us before,
So I had never seen them because I moved in July, and the documentation, in fact, I think you guys met in October of 2015, and I had no idea.
No, I totally understand that. I'm just saying in general, did you have any conversations with him? He was supposed to be after the campaign was over.
After the campaign, I spoke to him later that year in November. He announced to me that he was having a baby with a former staff member. I had no idea that was happening, and that he had gotten a divorce. His wife left him during the campaign. I had no idea that was happening, and I wished him well. And as far as I knew up until that time, everything was hunky-dory. He presents himself professionally. He's diligent. He's honest, hardworking. It was a tremendous family. Only until we discovered, actually, Robert Jackson, the senator, called me up and said, Ziad, do you realize that you're on the hook for over $100,000 at CFB? And I said, what are you talking about? And when I eventually communicated with your attorney, she said to me that we received a signed document by you and your treasurer dated accepting all of the things and penalties, including like it's $97,000. I remember asking her in your 7 years of working, had you ever seen anybody accept anything like that? And she said, no. And I said, I wish I'd received a phone call. I mean, not to say anything, but I mean, it was so extraordinary. And for me, I was shocked. And by the way, the envelope had Rasul Miller's address postmarked on it. I mean, stamped on it, but it was postmarked in Brooklyn. Rasul never lived in Brooklyn. I never lived in Brooklyn. Jason Eligio lives in Brooklyn. And so we assume this is our, the only person. Rasul eventually received the documentation from the CFB and asked Jason about it, and Jason said he'll take care of it. That's the last we knew about it. And then next thing we know, Robert Jackson calls me up saying, Ziad, this is in November, late October or November of 2015. When he calls me up, I have the text still. And Robert Jackson, he said, Ziad, this is the situation. I said, oh my God. And then I started communicating with her, started getting attorneys, and I find myself here, which I don't believe I would be here if I had somehow gotten that information first and was able to contest all of this and work with BLA and possibly work with Jason before he basically went undercover and disappeared.
Thank you.
So, Mr. Ramadan, that's not your signature on the notice response form.
Absolutely not.
And who did forge your signature, if you know, or if you'd like to speculate, and why?
My assumption is it was Jason Eligio, and I think towards the end of the campaign, so we discovered he was going through a very turbulent time in his life. We didn't know that. I raised a lot of money in that campaign, and I came in 5th or 6th with under 1,000 votes. It was really towards the end and after Bill Lynch passed away, Bill Lynch Jr. passed away, it really nosedived. I mean, top 3 things that can possibly happen is your campaign manager dies, there's an implosion in your leadership, all that happened. Between Lynch and Jason Eligio, there's a lot of friction, and they didn't get along with Bill Lynch III. And I think his life just started to spiral in a lot of different ways. He told me, my wife just finished the bar. I hope she didn't use me to pay for her legal fees. And then she came back from a 2-week vacation and then divorced him thereafter. So he was going through a very, very rough time. And I think that maybe he realized, especially when he read the complaints in 2015, he read the complaints and said, oh my God, this is all me. I'm the one, I'm going to be exposed. And he checked all of those boxes. I would have never accepted $97,000 worth of penalties. And I just think he was trying to hide a lot of his, because he's still a political consultant. He's still in the game. I went to the DA's office. I went to the New York NYPD. I've been interviewed by the DA. So has Rasul Miller. And they said, we've listened to your testimony. it jives, and we trust you, but we can't go after him. I said, mail fraud, fraudulent signatures. I mean, a crime was committed here, and we're the victims, and we're under the microscope now. And I think that and to me, I just feel victimized. And I went into this after 20 years of non-for-profit work, pro bono, working for my community in a variety from senior centers to non-for-profit organizations to the civil rights organizations, starting them in my community, really bringing Washington Heights and West Harlem, around them. I was on the board of UMass for 10 years, West Harlem Development Corps board for 10 years. And I've done all of this stuff for my community. I just thought that it can culminate in continuing to serve in elected office. And then Murphy's Law, my consultant dies, the most famous political consultant in the state of New York, and someone I admired, dies in the middle of my campaign. His son has a baby that same month, and they close their offices and move that same month, July of 2013, just prior to the elections. So his son has to navigate a funeral for his very famous dad at Riverside Church with dignitaries from around the month coming. He just had his first baby boy, B4 they call him, because he's B3, B4, and he's moving his offices, so everything's in boxes. And so he, when I spoke to him, I said, Bill, I need documentation. I can't go before the CFB without documentation. Unfortunately, because he had signed off on those papers. If Jason never signed off on anything, and I was able to communicate with you guys, there's some way we could have worked something. I could have gotten those answers for you, because those are not much, and I think we can give you justified answers. In fact, I produced copies from beginning to end of my Chase account, as he had run in 2013, from the inception to the very end, to the closing of the account, and I handed those. So the copies of the checks for everything that we're talking about is in your possession. So there is no malfeasance, there's no intention, there's no malice. We never did anything wrong. We had a tight team, and all the people that worked for us went on to do bigger and better things because we inspired them, because that's what we believed in. But at the end of the day, I'm really caught in this sort of bureaucratic trap because someone committed a crime. And Rasul and I were absolutely shocked to see our signatures on paperwork accepting $113,000. And I even said, have you ever seen this before? How unique is this? She goes, it's absolutely unique, because I've never seen it before. And I said, because I'm not irrational. I would never do anything like that. And I would stand up for justice, and I'd stand up for right, because that's what I do. I was the founding chair of the Malcolm X and Dr. Betty Shabazz Memorial. I'm sorry I sound so emotional. I was warned, don't be who you are. And I said, I got to tell you, if they don't know who I am, then how can I present my case and let them know that this is the kind of stuff that, first of all, I can't afford, but second of all, I would never do. It's just not who I am, if you look at my history. And I apologize that okay.
No apology is necessary. Thank you very much. We appreciate your putting yourself forward in that way. Anything further?
No.
Okay. Our next candidate is Julius Tajidin. So, Mr. Tajidin, I assume you've been here for a while, so you know the drill. I'll ask the CFB staff to tee up the issue, and then I'll give you the floor.
Good morning, Chair Schaefer, Executive Director Low Press, members of the board, and Mr. Tajidin. My name is Jason Yee, Associate Counsel for the CFB, and with me is Senior Auditor Victoria Telt. Before the board is the matter of the Julius Tajidin campaign in the 2017 elections for City Council District 9. Mr. Tajidin was a non-participant in the program. CFP staff recommends that the board find that the campaign committed violations of the Campaign Finance Act and board rules as follows, and assess penalties according to the penalty guidelines. Failing to demonstrate compliance with the reporting requirements for receipts, failing to file disclosure statements, and failing to respond to the draft audit report. The campaign contests the recommended violations and penalties.
Mr. Tajidin?
I missed the matching funds application or the deadline for, to get matching funds. Also missed the deadline for publication in the Campaign Finance Board mailer. Now, this was due to miscommunication. I thought I was timely, but then I was bogusly kicked off the ballot. To redeem my reputation, I decided to challenge the decision in court, and I hired, in fact, attorney Ali Najmi. The BOE and the ghost challenger did not challenge my petition, as they would have lost anyway, but it caused me nearly $6,000 in attorney fees. I still went to court and was awarded a judgment in my favor. I decided to use the Campaign Finance Board system to raise money and do my reporting and so forth. Numerous times the site for doing all of this was down. I should have snapshotted those notice pages, but the site would be down 2 and 3 times a day. Then they didn't have us, they were late in getting back to notify candidate, or at least me, that the site was up again. And then I'd go back on the site to try to do certain things, and, it was down again. The bank that I set up for my campaign terminated my account. I found myself behind the 8 ball and taking a lot of in-kind donations and using my own funds. Adding in my legal fees and in-kind contributions, the total value used was no more than $20,000. I do acknowledge that I didn't report. That was largely due to frustration and feeling that perhaps I was set up. We brag in this country how our elections are fair and orderly. I would say it's sophisticated. To make me or my campaign pay $4,000 plus would be a financial burden to me. And I would say that because of CFB's deficiencies, the board waive all penalties. I'm in court now with my father's estate. I'm spending my personal money to keep the estate solvent. I'm also involved in a lengthy court battle regarding my apartment, which was going on during the campaign. There's still money in the Campaign Finance Board account that I have not been able to collect. So that shows, there's no type of
What money is in what account?
like donations that came in. And so I keep on getting notices, you have funds that are payable, but because I didn't have the bank account set up I had it set up, and then, they terminated the account with, I don't.
So is there an account with money in it? Is that what you're saying?
Well, there's an account, like there's money that's been donated to my campaign that's here, yeah, with the campaign finance.
I'm confused.
So,
Referred to?
yes, so Mr. Tajuddin is referring to the NYC Votes Contribute account, which is basically a portal through which people can contribute to campaigns. Because of his bank account's closure, the account that was associated with NYC Votes Contribute, because that account was closed, there's $100 that is just sitting in that portal, basically waiting for a place to go.
Do you know what the maximum balance in that account was during the course of the campaign?
I'm not certain.
It's like around, it had gotten to maybe $1,000 in that range.
Approximately $800.
So,
That's what's left now.
No, approximately $800 at max.
at its max.
How much is left now?
$100.
The memo says at least 800 in credit card contributions.
Yeah, that's what I'm saying. So it was like close to 1,000. But I also had people telling me that they tried to donate, and they said the site, they were having problems. I also want to say that although I won in court, my name did not appear on all of the ballot sheets. And numerous people, my supporters, came and told me this. Now, of course, in the election district where I live, you wouldn't see that. Like everybody, and probably that's the only district where all the ballot sheets did show my name. But, the court ordered the Board of Elections to have my name put on many things that they had taken my name off of, like all publications and all that. And they failed to do that. And because I found myself struggling and being behind the eight ball, I didn't, the fact when you don't have poll watchers, you could really get set up. So you need poll watchers to go to every poll site and to examine those ballot sheets. And, I didn't have that. So anything could happen to me. But, I think the $4,000+ is steep. Under these circumstances, I think there's evidence showing that, I used mostly my money, and I was getting in-kind contributions. And it's just, I think there's evidence showing that, there's no nickel and diming, but when you're out there in the field, and I think I had the best ground game. So I'm out there, you got to use your own money because, you got to get cards, you got to get palm cards, your business cards and banners and things like this. And then, the amount of money for these things, they're usually like, maybe $100. So, okay, I started out wrong with all this. Maybe I shouldn't have gotten into this election without having a proper footing. But I think there were things, happening to me that were malicious. To have me removed off the ballot, and then when I challenge you, then, we're not going to challenge you. We're not going to challenge you. So that shows it was bogus from the very beginning. So there's a lot of stuff, and it's, you get frustrated, and, I'm a veteran, I've been in the military, and when you're out there in the field and, sometimes you're not crossing T's, you're not dotting I's, you got to keep it moving. And that's kind of, I found myself, using guerrilla tactics out there, and I was, grinding very hard. So it's a situation where, in court with my apartment situation, and the receipts, things are getting misplaced, getting lost, but so that's kind of like, where it stands basically.
Thank you very much. Would you like to respond to anything?
Yes, so I have a number of points. First, I would like to just say as an overarching issue, this is about reporting and the disclosure statements that were not filed. This is not an indictment of the success of the Tajudeen campaign. It's simply a matter of compliance with clear legal requirements for campaigns. With regard to the CSMAR outages, I actually have a record of CSMAR outages in the relevant time period from the from the date of the filer registration of the Tajudeen campaign, July 31st, to the date of the primary that year, September 12th, there were 4 outages. 2 of them were for 2 hours. 1 was for 1 day, and 1 was for 2 days. None of them lined up with the disclosure statement deadlines. As I stated, these were relatively short closures. I believe only one was given without notice. One occurred without notice. A lot of these were, maintenance or unforeseeable electrical outages. Campaigns were notified when the system went down. In some cases, before the system went down. There was back and forth between Mr. Tajuddin and the campaign liaison and CFB staff about outages and also simply how to use C-Smart. Moving forward with regard to the campaign's bank account closure, the issue here really is about reporting and disclosure. This bank account, the transactions within the bank account were simply not reported in the duration of the campaign. We found out about the contributions coming through NYC Votes Contribute when the bank statements were furnished at the enforcement notice stage. And ultimately, the issues with the closure of the bank account are not germane to the campaign failing to submit disclosure statements. These are periodic disclosure statements. Mr. Tajuddin was reminded regularly by a CFB staff liaison that these deadlines were upcoming. There's a contact record at one point where Mr. Tajuddin states that he'll do his best to comply and was not heard from again. With regard to the ballot issues, again, it's very unfortunate, but the CFB has no control over the BOE's decisions with regard to ballots and petition challenges. These are completely unrelated to the reporting issues that the campaign had.
Make a comment on that. Yeah, they work in tandem together. So, you might be different organizations, New York City Campaign Finance Board, but, they work together. The Board of Elections and the Campaign Finance Board, because they do work together. It's all tied in, together with the law. And you can't say that they're separate like that because, they work too closely together. I mean, anybody here with common sense, you have different boards, but community boards work with the borough president, although the law says they're separate, but they work together. The borough president appoints board members. So within the law itself, the structure, they work together.
Can you estimate the total expenditures of your campaign?
Including in-kind?
I'll take both numbers, if you would. Yeah, yes is the answer, including in-kind. But I'd like to know the portion that you estimate to be in-kind.
Well, the portion of in-kind, maybe 10,000. And then my personal contribution, like 10,000.
And did you actually get any contributions?
Yeah, we saw that.
Yeah, I got.
But you were able to. Okay.
Right.
That's fine.
But when I got when the account closed, I used the money toward with my toward the campaign.
Thank you.
All right, thank you very much. The board will now go into deliberations. All right, thank you for your patience. We're back, having deliberated. We have 5 candidates, including the 2 who appeared today, that we need to deal with. And so I'll go through them in order, and then I'll ask, this is in the nature of a proposal and motion, which I'll then ask the board to approve after I have gone through all 5 candidates. The first candidate is Ziad Ramadan, and the board proposes to find the alleged violations. One sec. The board proposes to find the following violations and impose the following penalties. 1, failing to report transactions, $641. 2, failing to demonstrate compliance with reporting requirements for receipts and disbursements, $2,500. 3, filing late disclosure statements, $100. 4, failing to demonstrate compliance with subcontractor reporting and documentation requirements, $200. 5, accepting contributions from corporations, limited liability companies, or partnerships, $500. 6, accepting contribution from an unregistered political committee, $250. 7, failing to document transactions, $200. 8, making cash expenditures greater than $100, $1,644. 9, failing to demonstrate that spending was in furtherance of the campaign, $1,862. 10, exceeding the expenditure limit, no violation, no penalty, for a total penalty of $7,897. Next, Michael Scala.
He just has a public funds payment. We can do that in a second.
Okay, we'll do that later. Next, Scott Stringer. Following violations and penalties. 1, accepting over-the-limit contributions, $250. 2, accepting a contribution from a limited liability company, $125. 3, accepting a contribution from an unregistered political committee, $250. Total penalty, $625. Next, Julius Tajidin. Following are the proposed violations and penalties. 1, failing to demonstrate compliance with reporting requirements for receipts, $500. 2, failing to file disclosure statements, $2,500. 3, failing to respond to the draft audit report, $500, for a total penalty of $3,500. Finally, Richie Torres. 1, failing to disclose a political committee, $100. 2, accepting an over-the-limit contribution, $125. 3, accepting contributions from corporations, limited liability companies, or partnerships, $250. 4, accepting contributions from unregistered political committees, $1,000. 5, failing to document a transaction, $50. 6, submission of false or fictitious information, $3,500, for total penalties of $7, failing to demonstrate compliance with intermediary reporting and documentation requirements, $200, for total penalties of $5,225. And yes, and finally, James von Bremer. 1, failing to report transactions, $154. 2, failing to demonstrate compliance with cash receipts reporting and documentation requirements, $165. 3, accepting over-the-limit contributions, $4,263. 4, accepting a contribution from a limited liability company, $350. 5, accepting contributions from unregistered political committees, $2,750, for total penalties of $7,682. So that is the motion. Is there a second?
Second.
All those in favor? Aye. Opposed? Abstentions? Motion carries. And so that is the end of that item on our agenda. We also need to vote on, Amy, why don't you explain what this is?
The staff is recommending a post-election payment to candidate Michael Scala of $3,042.
All right, I'll move the approval of that payment.
Second.
All those in favor?
Aye.
Aye. Opposed? Abstentions? Motion carries. We also need to vote to ratify the special election public funds payment. Do you want to tee that up for us, Amy?
The staff recommended and Chair Schaefer approved, and the staff is asking the board to ratify payments made for the 45th Council District special election made on April 26th and May 9th. Monique Chandler Waterman, $7,125 on May 9th. Farrah Lewis, $7,125 made on May 9th. Jovia Radix, $93,442 made on April 26th, and $41,854 made on May 9th. Jamela Rose, $67,663 made on April 26th, and $16,441 made on May 9th. Adina Sash, $3,519 made on April 26th, and $34,310 made on May 9th. And Ricky Tulloch, $121,106 made on April 26th, and $19,614 made on May 9th.
And I move the ratification of those payments. Is there a second?
Second.
All those in favor?
Aye.
Opposed? Abstentions? The motion carries. And finally, there's an item that you need to explain.
Finally, the staff is asking the board to dismiss a formal complaint made against the Liam McCabe campaign in 2017. All the issues raised in that complaint were answered adequately by the McCabe campaign. So the staff is recommending that the board dismiss that complaint.
So moved.
Second.
All those in favor?
Aye.
Opposed? Abstentions? Motion carries. Finally, I will move that we go into executive session, and since we have no further business to transact, that we then go adjourn directly from executive session. Is there a second?
Second.
All those in favor?
Aye.
Aye. Opposed? Abstentions? Motion carries. The meeting is over.